All right, calling our next case, People versus Lucynski. This is a 15-minute mini oral argument on the application. You may reserve time for rebuttal, but we ask that you keep track of your own time if we do not use it all up. And you may begin whenever you are ready.
Good morning, Chief Justice Clement, if I may please the court. My name is Bernard Jockins. Here at council table with me is my paralegal, Jeff Newton. And this is our case. We're going to talk about the exclusionary rule for a little bit. And there's essentially two cases that I think that are right on point I'm going to touch on a little bit. So right now, the exclusionary rule is really hanging on by its last tooth that's gradually been filed away or chipped away over the years. And Mr. Lucynski's case here personifies the reason and necessity that we have an exclusionary rule still. And it ultimately protects citizens, it protects civilians, in addition to deterring bad police conduct and ultimately protecting our rights. Now, in this circumstance, Deputy Robinson's conduct was not found to be a reasonable mistake of law, and it was nothing more than an unwarranted hunch that didn't mean anything to amount to reasonable suspicion, which the Constitution is supposed to protect here. So we did not have reasonable suspicion, and there was not evidence to support an inchoate hunch. So in this circumstance, if the exclusionary rule doesn't fit, it doesn't pertain, I'm not really sure set of facts where it would. And so I'd like to talk about one of the cases where this is really based upon, and that would be the Hine case. And right into Justice Sotomayor's dissent, where it indicates that there is nothing requiring us to hold that a reasonable mistake of law, and that's a reasonable mistake of law, to justify a seizure under the Fourth Amendment. And there's actually quite a bit suggesting the opposite. And this court had already found that the mistake of Deputy Robinson was one of an unreasonable nature. And as I was mentioning about some of the courts and the way that they review some of these cases, another state, the state of New Jersey, and I believe the case is Carter. So not every court follows the reasonable mistake concept that this court should not extend it to include unreasonable mistakes, as this court already had found. So what I'm getting at is that state constitutions at times offer more protections than the U.S. Constitution, and maybe that this is something that should be taken into consideration in this circumstance, like in the state of New Jersey in the Carter case. And this isn't a penalty to law enforcement. And the purpose isn't just to prevent bad police conduct, it's to protect citizens.
Does Herring versus United States set out the governing test for the application of the exclusionary rule under the Fourth Amendment in this case?
Justice Zara, would you please repeat that? I didn't hear the name of the case you referenced.
Herring versus United States, is that governing? The Court of Appeals below relied on it quite a bit.
I think it's more on Hine, Judge, as far as where Herring is concerned in this. I think that this is more of a distinct scenario where we don't have a reasonable mistake of law in this scenario.
So did the lower court, the Court of Appeals here, was it erroneous in looking to Herring?
I can't say with a degree of certainty one way or another, Justice Zara, as far as the way that was applied. I know that right now in this circumstance that we have a situation where there was not a reasonable mistake of law and there was no independent evidence to support just a random hunch or maybe it was something that was more of a subjective hunch, like in the Wren case.
I assume the distinction is, so Herring found that there is no deterrence if the mistake was a result of negligence of understanding the law, but I assume the distinction is between what's a reasonable mistake and what's an unreasonable mistake.
And Justice Welch, I don't think that this is a situation where that necessarily applies, because in this situation, for lack of a better way to explain it, it was unreasonable that there was to be impeding traffic when there was no traffic there. So I believe that this is really, distinguished from that case.
If we agree with you that there could have been pretext here, that, as you said, the officer was investigating a hunch and whether that was pretextual or not for the reason for the stop, is that something we can decide, or is that something we'd have to remand for the trial court to decide, given that it has a lot to do with credibility, the officer, whether the reason given is believable?
In my humble opinion, I think this is something for this court to decide. We did have a remand before, and that's what brought us back up, Justice Welch. I think that it will probably be easier for this court to make an unambiguous decision regarding what is essentially the fate of the exclusionary rule.
Thank you.
You started your argument by saying there are 2 points to the exclusionary rule. One is to deter police misconduct, and the other is to protect citizens.
Correct. And there are circumstances in which a reasonable mistake of law.
But do you have to have both categories?
I could break that down a little bit if I may, Justice Zara. You have reasonable suspicion. Let's just say in this case or any case you have a reasonable suspicion. Officer has a hunch. They have some sort of sense. And there might be some sort of independent evidence that would support that hunch. Something that would be independent. And then you would have a reasonable mistake of law. However, when you have just a hunch and there's nothing that supports that, like in this situation, which the court already assigned, there is no traffic. So no reasonable mistake of law. And so essentially what this court or any court would be doing is they'd be rewarding police conduct that not only is not stellar, but it seems like it could potentially be fictitious or open the floodgates for pulling people over for subjective intent that has nothing else that could even hit independent evidence to support that hunch.
Well, you agree that the impeding traffic statute was never interpreted or given meaning by appellate court prior to these proceedings, correct?
Absolutely correct.
So what's the purpose? What purpose is served in applying the exclusionary rule now that that has been clarified?
What's the purpose of the exclusionary rule in this circumstance or in general?
No, I mean, the idea is to prohibit bad police conduct, right? And even if the mistake of law is unreasonable, looking at this statute, the statute was undefined. Now that it is defined, what is gained by applying the exclusionary rule?
Well, what's gained by it is, for one, there wasn't a set of facts that merited the stop in this case. And it's going to not only deter this type of police conduct, it's going to make it safe for everybody.
Well, I guess my point is now that the law is clarified, there's no exclusionary rule in play. If someone makes a stop in violation of the statute that's been clarified, it's clearly not going in. I don't see how you're deterring future bad conduct. The deterrence of future bad conduct is the actual interpretation of the statute. We now know what it means, and it doesn't mean 2 cars stopped in the middle of the road with no other cars in the area.
And that's correct, Justice Zara. But with all that in mind, I understand that there's this big concern over courts, law enforcement in particular, of having timid law enforcement that are very reluctant. And it's a difficult job, and you have to make on-the-spot decisions. So in this circumstance, we'd rather have police that are more informed, making those rush judgment on-the-spot decisions that somebody has to do something clutch and under pressure versus someone that's just doing something randomly. And I understand what the court is saying, that this issue has been defined, it's been knocked out, it's been clarified. But this is preventing the harm in the future, in particular in this circumstance, directly to Mr. Lucynski.
I probably overstated it. There was one unpublished Court of Appeals decision that would have agreed with the position taken by the officer here, right?
Unpublished.
Oh, yeah.
Salters.
The Salter decision, that I didn't think that Salter was really on the table anymore from the last opinion
No,
order from the court.
I get it, but do we really want to encourage non-lawyer law enforcement to second-guess opinions of the Court of Appeals, even if they're unpublished?
I think we need law enforcement to be informed and directed, and that's all I'm asking for. We're asking for law enforcement to be adequately trained, adequately informed, to be able to make these on-the-spot decisions instead of have someone
Who's supposed to train this officer and say, Salters is wrong?
I don't think you need to say a specific case. I mean, a lot of those cases, most police officers aren't going to know,
All
and I
right.
can't expect them to know.
All right. Go ahead.
And so, as I was saying, Lucynski actually resolutely answers the questions in the negative, that an officer's unreasonable mistake of law triggers the exclusionary rule.
Let me ask you a question, because you said this is I think your argument is that this is the paradigmatic case for exclusion, application of the rule. You said something to the effect of, if it doesn't happen here, I can't imagine another case.
I couldn't have said it any better myself, Justice Viviano.
Right, or something to that effect. So the officer, you kept saying the stop here. There really was no stop here, was there? Your client already stopped and got out of the car all on his own, if I'm remembering the facts here correctly.
Somewhat. He got out of the car, and then, he was asked to identify himself with his ID, and then there was initiated
He
police
walked up to
conduct.
the house and indicated that it was his friend's house, or something along those lines. But so the officer, had a hunch that something was up. Turned out his hunch was correct. But the adverse action here, the thing that is so offending to our notion of justice, is that the officer pulled into the driveway as opposed to leaving his car on the street. Because if he left his car on the street, I think he could have approached your client and asked the same questions, couldn't he?
Maybe, but not only did he pull behind him, he blocked him in. He wasn't getting
Well,
out.
it was a single-lane driveway, and so he pulled onto the driveway so as to pull off of the street. There's a difference of opinion, I would say, on this court as to whether that effectuated a seizure. But let's say that it did, since that's what the court ruled. But if he left his car on the street, he wouldn't have effectuated a seizure, and then he could have approached your client and engaged him in conversation, couldn't he? I mean,
There might have been an argument that would have been of a welfare stop or a welfare check or something to that degree, but I don't believe that would have been an actual stop or pull over.
But so I'm just trying to pinpoint what it is. We're really concerned about deterring is police officers on rural roads pulling into single-lane driveways. And that's why we need the exclusionary rule in this case, as opposed to leaving their car at the end of the long driveway on the road and approaching your client. That's what'll be accomplished by this case if we exclude the evidence.
That would be part of the things that are accomplished. Justice Viviano would prevent that type of conduct in the future. In this circumstance, police would be more informed as to when they have interaction with someone that may or may not be based upon a hunch, that may or may not have something that's independent to justify that. And the good thing for this court and in general is, through my research, I haven't found a court that allows unreasonable mistakes of law to validate any sort of warrantless search or seizure, which that would actually be a huge constitutional paradigm shift. And, I would like to think
That's all we're really deciding in this case, correct?
Correct.
The prior opinion in Lucynski established
yes.
that these were not reasonable, was not reasonable suspicion, right? And there was no evidence to support the hunch that the illegal drug transaction had taken place, and that ruling hadn't been appealed. So we're talking about an unreasonable interpretation, which this court has already said it's unreasonable. The question is, under those circumstances, and while there may be a debate of whether or not those prior holdings are correct, the holding that we're looking, or what the question that we're looking at here is whether an unreasonable mistake of law is a basis to not apply the exclusionary rule.
And where I'm getting at in my brief, and then I'll leave this and rely on the rest, is that I believe that unreasonable mistake of law, a court shall apply the exclusionary rule because it goes so beyond belief, and the court doesn't even.
Perhaps, taking a step further, perhaps there is an argument in a particular case that that the good faith exception to the exclusionary rule should be made. But here, in this case, the prosecution didn't argue a good faith exception to the exclusionary rule.
That's correct, and I don't
So
think
we
it
have a very
applies, Justice.
specific issue that we're looking at, correct?
Correct, Justice Kavanaugh.
Okay.
And that is all I have at the moment. Thank you.
Good afternoon, Eric Wanek on behalf of the Appellee, people of the state of Michigan and Tuscola County. This court has already ruled that this was a traffic stop, that there was no reasonable cause, that this was not impeding traffic, and then that there was no reasonable mistake of law that has occurred here that could forgive the Fourth Amendment violation. So our analysis then has to turn to whether or not the exclusionary rule should apply. That is a separate and distinct question. That's why this court remanded the matter back down to the Court of Appeals, I believe, to have that question answered. Because just because we have a violation of the Fourth Amendment doesn't automatically equate to application of the exclusionary rule, and that's pretty clear in the case law. The standard here requires a de novo review of the entire case to determine whether the exclusionary rule should apply. And I think that's important. That's an important standard here because our best evidence against the exclusionary rule is the body cam footage that was admitted at the time of preliminary examination and was attached as an exhibit to our brief. Because when you watch the interactions of this officer and this defendant, you don't see the kind of police conduct that the exclusionary rule was designed to enforce and deter. I would disagree with counsel that we've chipped away at the exclusion rule. I think we have expanded it, unfortunately, beyond what its good intentions were. Its intentions were always to deter unconstitutional police conduct by making the officer pay the heavy price of losing the evidence of what they felt at the time was good police work. The benefit of the exclusionary rule was never designed to benefit just one defendant, which if it was expanded here, that's what we would have. It would just benefit defendant Lucynski because we have to look at what is the societal interest.
Counsel, I agree that the officer here was very polite and acted very appropriately on the video. I do. But is politeness the standard for whether a seizure has happened and whether evidence should be excluded?
No, absolutely not.
And so you're arguing that they're saying that defendant's asking for an expansion, and I mean, I could flip that and say what you're asking for is an expansion. Historically, the law in Michigan has been really clear that if there's a seizure and, the good faith exception doesn't apply, a reasonable interpretation of the law. So we're now here, I think, particularly arguing that perhaps it's an unreasonable interpretation of the law and should it expand to that? That feels expansive to me.
Well, that's correct. I mean, I think, just what you've kind of hit the issue here is, is this a reasonable or unreasonable, violation of the Fourth Amendment? Because if it is unreasonable, then exclusionary rule is supposed to apply. If it is a reasonable violation, which that's basically my argument, is that it shouldn't be extended because the societal interest of extending it to cover a case like this under these circumstances is not necessary. This is not the kind of police conduct, in my view, that and as well as the Court of Appeals' view, that the exclusionary rule was designed to prevent. I mean, I think the Fraser Court in 2007 says it best when it says, we have to avoid a rigid, unthinking application of the rule because it has a significant impact on society and frustrates good police work. So, we can't just blindly apply this to every situation, which is why the law makes us answer that question separately of whether or not we should expand the exclusionary rule on a case-by-case basis. In other words, do we want to send a message to other law enforcement that this kind of conduct cannot be allowed? And so when I look at the facts of this case, I just don't see it, and neither does the Court of Appeals, which is why they found that this was a reasonable violation of the Fourth Amendment.
So I'm looking at a case from the Fifth Circuit, Lopez Valdez. It specifically noted that if officers are allowed to stop vehicles based on a subjective belief that traffic laws are violated and no such violation occurred, the potential for abuse of traffic infractions as pretext for stops are boundless and costs to the right to privacy excessive. What's inaccurate about that statement?
Well, it all goes back to, the Hine case with regards to, is there a reasonable mistake of law? And I get what the court is saying in that particular case in the Fifth Circuit, but, is the officer's read on this situation, was it unreasonable? And I know this court has ruled on that issue, but you look back at the law that was in place with the Salters decision, that, this officer thought he was making a valid stop. This was, in all sense, very similar to a Terry stop. This was an officer who thought he saw something that was suspicious, that he made contact with this individual. He thought he had the ability to do so because of what he had observed up until that point. And then, that spiraled into additional probable cause to continue the stop, to investigate for a drunk driving. I don't think this officer ever testified that he automatically thought he was stopping a person that was going to be under the influence. That was not, he wasn't searching for a reason to stop him to investigate this defendant for that. So I think he had a good faith belief that his interpretation of the statute was accurate. The Court of Appeals, in an unpublished opinion, actually agreed with him. And then, it turns out that that was an error on his part and found to be an unreasonable mistake of law on his part. But still, you have to look at, given that mistake of law that's now been determined to be unreasonable, but you still look at, he had a rational basis for making the decision. Whether it's reasonable or unreasonable, he wasn't engaging in the kind of conduct that the exclusionary rule was designed to prevent. Again, I go back to what is the societal message we want to send law enforcement about this kind of conduct? What kind of conduct here was so egregious that we have to make that bold a statement? If we extend the exclusionary rule in a case like this, all we're doing is benefiting this defendant, and that's not what the exclusionary rule was designed to do.
How do you counter, your opposing counsel said that he has not located any case law that has held that an unreasonable mistake of law still justifies not applying the exclusionary rule. What would be your best case for saying that it would be, and you're contending that that's an expansion. So what is the case that establishes your point that you just made?
Well, and I'm not saying that the unreasonable mistake of law then equates to not applying the exclusionary rule. Again, I see those as separate questions. I see that, we've made a determination. I think the unreasonable mistake of law certainly does not forgive the Fourth Amendment violation because, we had a determination that there was a misinterpretation of the law. So then we have to answer, well, does that forgive the violation to the point where there is no Fourth Amendment violation? The answer to that is now no. So now we have to move on from that. And we have to ask ourselves, okay, well now, so what? What do we have to determine next? Well, the separate and distinct question of whether the exclusionary rule applies.
Would we be the first court to decide that, or have other courts made that analysis? I agree with you. Fourth Amendment violation is a separate inquiry from then whether or not exclusionary rule applies. And we have this being that is the Fourth Amendment violation with an unreasonable mistake of law, and we're trying to figure out how do we apply the exclusionary or whether it should apply in a context like this. Are we just sort of making uncharted territory, or are there other courts who have, I can't imagine that kind of violation is really that unique or rare that no other court has grappled with it and found consistent with the position you're advancing.
I have not run across one myself, but, that was partly because I saw this as accepting the fact that there is an unreasonable mistake of law, and then trying to move on from that point to justify why the rule shouldn't be applied. And that's where I go back to, you know, I think Frazier's probably one of the stronger cases in Michigan on that issue, because in that particular case, you know, they do the analysis that is required here, which is, again, you know, this is designed to be more of a societal remedial measure, not one that benefits a singular defendant. So that's why I continue to say that, you know, we cannot extend it in this particular case, because, again, the case requires that de novo review where you have to look at what happened during this stop and what's the message we want to send. I mean, and to extend the exclusionary rule to this situation, I think, has a very detrimental impact on good police work, and that's one of the things that case law says you have to avoid when you're making this kind of decision, or whether to add to the law that's already been added to over and over again since the inception of the exclusionary rule. You run the risk that officers become afraid to listen to their gut, to investigate something that they feel is not right.
Wouldn't it just be suggesting that officers should be concerned about acting unreasonably? As opposed to, because reasonable mistakes of law, like
Sure.
You know, that the rule isn't going to necessarily apply because
There's no Fourth Amendment
we're
violation.
humans and we
Right.
make reasonable, you know, like, but we're talking about an unreasonable mistake of law. So this, like, I don't, like, what is it that we're saying that police officers are going to be deterred from doing? Acting unreasonably?
Well, you're going to be saying that, you know, contact, just simply contact, followed up by a belief that there was a violation of the law, however wrong it may turn out later to be.
However wrong.
However wrong it might later turn out to be. As long as, you know, what you're wanting to deter is the kinds of things that the exclusionary rule was initially created all those years ago to deter, which was, you know, pretext stops, you know, engaging in just shoddy police work, basically. Here, this officer did his job, believed he was doing it correctly. He was told later that he wasn't. But, you know, another officer looking at what he did here would probably make the same decision, because it is not the kind of thing, the kind of conduct, when you look at it de novo, that the exclusionary rule was designed to prevent. This is, you know, it was designed to prevent lazy police
But
work.
I mean, I think you're sort of mixing these together. You're saying another officer looking at this conduct would maybe make the same mistake. But if it's an unreasonable mistake of law, wouldn't the natural assumption be that another officer wouldn't make that mistake? Because it's unreasonable for this officer to have made it.
Well, I think that message has already been sent, and that, you know, in the original ruling of the court, and that, you know, now folks know that this is what the impeding traffic statute is about. They now know what constitutes a police contact, as was ruled in the previous decision. But is it necessary to send the message using the exclusionary rule to exclude the evidence beyond the message that's already been sent?
I add one more. They now know the Court of Appeals in Salter was wrong.
Yes,
Was something they did not know before.
correct. That message has also been relayed.
So if this court deems that to be unreasonable, shouldn't we require there to be something more on the part of the police officer that they did wrong that would tilt it to invoke the exclusionary rule?
I think to exclude the evidence in this case would be an unnecessary punishment to send that message to law enforcement. They now know the court's viewpoint on the law surrounding what the officer did. But you got to go back to, is what the officer did in spite of that so bad that it is necessary to punish the conduct? And you're punishing the conduct for the reason that you want the message to be a deterrence to all law enforcement, that if you engage in this kind of conduct. I mean, you now know, officers now know, if they do exactly what this officer did, they will be violating the Fourth Amendment, and then they'll be on the ropes trying to justify it. They now have notice. So if they engage in this kind of conduct as what the court ruled in the previous opinion,
They're not going to be in a position to do what this officer did because there's now an opinion from this court saying
correct,
that Salters was wrong.
correct. So
And that you can't do this. So if they do it in the future, clearly the exclusionary rule would preclude that evidence.
correct, and they can't hide behind
They
their
had-
lack
they
of
had
knowledge.
Salter- They had Salter that they were looking at before,
Is that
which
another
this
way of
court deemed to be
arguing?
unreasonable.
Sorry. Is that another way of arguing the good faith exception? And was that argued here?
I didn't argue the good faith exception because I interpreted the court's previous ruling that that probably wasn't going to be feasible, because it was already determined that there was an unreasonable mistake of law, and you know, I think I argued that the first time around, that this was a reasonable mistake by an officer who acted in good faith on what he thought the law was. So now my position is, I think I'm here to defend whether he should be additionally punished, and that's the thing. I mean, this suppression, you know, the officers now know what the law is, the other officers out there. They now know what the law is based on the court's previous ruling. This officer doesn't need the additional punishment to get that message sent even stronger, because they now know the law, and they will have acted with knowledge of that law if they act the same way. But in this case, looking at this case, which is what we have to do, suppression is a very heavy-handed punishment to inflict beyond what the message of the law already is. And it will only benefit this defendant.
Thank you.
Thank you very much.
I think I might have 2 minutes.
You have 9 seconds.
I'm going to use all 9 seconds.
All right.
And grant what I'm asking for, and please, make a finding that unreasonable mistakes of law will not allow evidence to come in. Thank you.
Thank you. Thank you both. The case will be submitted.